The federal law banning people that are ages 18 to 20 from buying a handgun from FFLs has just been struck down. Let's go ahead and talk about it. What's up, Wolverines? Welcome back to my channel, John Crump News, where we discuss everything 2A related. I'm your host, John Crump. I'm an investigative journalist that keeps an eye on the gun world, and I want to tell you about an exciting case today. But before we get to that, like, comment, and subscribe. It really helps amplify my voice. So, in Virginia, there is a case called Frazier versus the ATF. This case deals with the federal prohibition of the selling of firearms via an FFL to people between the ages of 18 and 20. If you don't know, which I'm sure you probably do, in order to go through an FFL to buy a handgun, you have to be 21 and older. Well, John Frazier decided that he wanted to buy a handgun, and he is under 21, and he wanted to go through an FFL. He and a few other people sued in the Eastern District of Virginia Federal Court, the Richmond Division to be precise, and he argued that the government could not ban him from buying a gun through an FFL because there is no historical analogs to say that the government had the power to do that. The government tried to argue that he didn't have standing because he could get his parents to buy a gun through a straw purchase and give it to him, which is ridiculous. In Virginia, you can be 18 and over to buy a handgun, but you just can't buy it from an FFL. That's one of the reasons why universal background checks in Virginia does not apply to 18 to 20-year-olds in respect to handguns. The government also tried to argue that it could ban people under the age of 21 from buying handguns from FFLs because it could ban alcohol from people under 21. The judge summarily dismissed this because he said that there is nothing enshrined in the Constitution that says you can drink, but there is something in the Constitution that says you can bear arms. Lots of anti-gun groups submitted amicus briefs. None of those worked to persuade the judge in the case. The judge could not find any historical analogs that said that you could ban anyone from under 21 from owning a pistol. The judge said that the state did not meet the burden to show that the law is consistent with the original text, history, and tradition of the Second Amendment, the Bruen decision. So this ran afoul of Bruen and is just another victory that shows how important Bruen is to the whole entire gun space and to the whole entire Second Amendment community. The judge issued a summary judgment for the plaintiffs and denied the state's motion to dismiss the case. The next steps would be the government appealing to the Fourth Circuit Court of Appeals. I am sure that they are going to ask for an emergency stay on the decision, and the Fourth Circuit is really anti-gun, so I could see them going ahead and granting that stay until they can hear the case. I cannot stress how big of a win this is. This is a summary judgment. This is more than just a preliminary injunction or a permanent injunction. This is a summary judgment. So this is a really big deal, and this is a massive blow to the ATF. Although I do think the decision will be stayed by the Fourth Circuit until they can hear the appeal, which could take forever. But this is a massive victory. So it's time to celebrate, pop champagne, and everything else. All right, guys, that is it. Stay ever vigilant, stay ever free. I have a Discord. You can go to discord.io/crump and join the chat, and we can talk about this stuff. All right, guys, that's it. See you later. Wolverines, motherfucker.